Good morning, Mr. Bursch and Ms. Toskey. It is nice to see you both. This is our final case this morning. It is the County of Ingham, Jackson, and Calhoun versus the Michigan County Road Commission. You each have 15 minutes. Mr. Bursch, you can try to reserve some of that. I know you know how to do it. And if you are prepared to proceed, you may go ahead.
I am. Good morning, Your Honors. John Bursch on behalf of the pool. I plan to reserve 3 minutes for rebuttal. Madam Chief Justice, and may it please the court. The Court of Appeals published decision below made 3 substantial errors that this court should correct. First, the parties' contract said only county road commissions can be members of the pool. At the time those contracts were executed in the mid-1980s, everyone understood that road commissions were different government entities than counties. And the statutory amendment in 2012 did not change what the contracts meant when executed nearly 30 years earlier. The pool members could have included counties, but after thinking it over, they chose not to assume the greatly increased risk of a county's general liability. After all, the pool insures roads and road equipment. A county's general liability can include virtually anything, like Genesee County and the liability arising from the Flint water crisis. Public policy does not require the pool to take on counties as members. Second, the parties' contract said withdrawn members can be treated less favorably for surplus equity distributions. That makes sense. The plaintiff counties want all the upside and none of the downside. They want to take the surplus and leave all their liabilities with the members who stayed behind. The plaintiff counties knew that this was how the pool worked when they joined it and when they left it, and public policy does not require the pool to treat withdrawn members better than members who stay. Finally, the Court of Appeals didn't understand the purpose of paying premium into a self-insurance pool to receive insurance coverage and claims administration. That's it. And the plaintiff counties still have coverage today for liabilities that arose from plan years before they withdrew. For example, if a young child was injured in 2010 by an Ingham County road vehicle, when that child becomes an adult, she could still file a lawsuit and the pool would be responsible, even though Ingham County no longer pays premium to the pool. It is the plaintiff counties who demand a windfall by taking the pool's reserves and leaving the pool holding the bag on the plaintiff county's past liabilities. This court should reverse and reinstate the trial court's judgment for the pool. I'm happy to answer your questions.
Thank you, Mr. Bursch. Justice Clement.
You fit a lot into that minutes. Can you talk a little bit, and I figured you would get there if we let you keep going, about a refund and whether or not that's the same as a dividend or a credit, and how we should be thinking about that?
Sure. Well, when we're talking about a surplus equity distribution, we're looking at very particular documents that the parties agreed to. The Declaration of Trust, Section 9F, which is at page 6A of the appendix, and the Interlocal Agreement, Section 3H, which is at pages 35A to 36A of the appendix. And they both say the same thing that they've said for 35 years, that payment of surplus equity is in the pool's discretion, and the pool can treat withdrawn members less favorably. In other words, surplus does not belong to the members, it belongs to the pool. Let's say that Ingham County had continued as a pool member, but they had way more accidents than anybody else because they had done a negligent job keeping up their roads. It would be entirely up to the pool to decide, the pool's board to decide, that Ingham County, as a member, wouldn't get any surplus equity distribution, even if everybody else was getting a surplus equity distribution. And certainly for the reasons that I stated in my opening, when someone withdraws and their liabilities are left behind with the pool for all of the plan years when they were members, but they are no longer paying premium, the pool has discretion not to give them any of a surplus equity distribution. And so you don't need to worry about dividends, you don't need to worry about interest. All you need to do is look at the plain language of the parties' contracts as they executed them in the mid-1980s.
Okay, thank you.
Justice Welch.
Sorry, button. No questions. Thank you.
Justice Zahra.
Thank you. Mr. Bursch, you've articulated a concern that if the position of appellant is accepted, that the pool will have to insure the entire county, and this is a risk they did not they did not plan for or cover. But help me understand when the county commissioner, I'm sorry, when the road commissions were done away with, why isn't it that just the county board of commissioners simply absorbed the road commission and act as the commission, and that any insurance that the commission had would apply to the board of commissioners as road commissioners, such that there is no extra risk. It's simply the risk that was already envisioned by the pool. Is there really a problem if here is what is the basis for concluding the coverage is much broader than what was originally agreed to between the road commission and the pool?
Yeah, Justice Zahra, all the insurance coverage that the pool writes would have to be rewritten. So for example, under the existing coverage that these road commissions would have had, it would have included coverage if a road commission driver in a road commission vehicle had caused an accident and injured persons or property. Well, that type of coverage would apply equally to county persons and county vehicles that don't have anything to do with road commissions. It would involve public health officials.
You say that, but why is that so? If the language says road commission drivers.
Well, if it says road commission drivers, that's helpful. But these are general liability policies for road commissions. And so they don't always use language that is particular to road commissions. So what the pool did is they asked the counties what they wanted to do. And the counties suggested that maybe they would like to continue moving forward with the pool. And the county board or the pool board considered whether they wanted to rewrite all their policies and restructure the pool to accommodate this change. I mean, it's logistically possible. There'd have to be a lot of work done. And they voted 60% to 40% against that. And it's really not any different than if you had, say, a pool for villages. And let's say that the city of Detroit annexed a village. Well, the city of Detroit wouldn't qualify to be part of a village pool. And it's up to the village pool then whether it wants to decide to let Detroit in, even if it was on a limited basis, only to the extent that it was insuring other villages. There's no public policy that forces the pool to take members that don't qualify.
Okay, so Jackson did not opt out. Did the pool kick them out?
Essentially, yes. Once they dissolved, they were no longer eligible for membership. So it would be like the village being annexed by the city of Detroit. The city of Detroit, as the village's successor, would not be eligible for a village pool in the same way that Jackson County, being a county, is not eligible to participate in a pool for road commissions. And again, everybody understood that. These documents were executed in the 1980s, and there was no question then that road commissions and counties were different entities. And simply because the 2012 statutory amendment allowed a county to dissolve its road commission and assume those powers, functions, and duties didn't change the understanding of the parties as to who was eligible for pool membership.
After there was a dissolution of the road commissions by all three counties, Calhoun and Ingham signed withdrawal agreements. Jackson did not. Did Jackson continue to pay in the subsequent time when money was requested of the rest of the pool members?
I'm sorry, Justice. I didn't hear the very tail end of the question. You said Calhoun and Ingham signed the agreements. And what about Jackson?
Jackson did not. And so
Right.
when it was time for counties in the pool to pay more money into the system, was Jackson requested to pay money, and did they pay money?
They were not requested, and they did not pay money. In fact,
Were
as of
other members of the pool requested to pay money at that time?
oh, sure. The pool members annually are always requested to pay premium for that coming year. And when Jackson and Calhoun and Ingham all withdrew through dissolution, not only did they stop paying future premium, but they were refunded the pro rata portion of the premium they had already paid for that plan year.
Thank you.
Yeah, and just to finish up on that, and that's part of the problem, is that if a liability for, say, Jackson County were to arise today, like in the hypothetical of a child who was injured in an accident by a county road vehicle, the pool would be on the hook for that liability if it took place while Jackson Road Commission was a member, but Jackson would no longer be contributing to premium, nor would it be required to come back to the table and ante up if it was necessary for an extra infusion of capital.
Mr. Bursch, I think I skipped Justice Cavanagh, and I did not mean to. Justice Cavanagh.
That's okay. And no, I did not have any questions. I'm okay.
Okay, back in my order, Justice Viviano.
Yeah, thank you. Mr. Bursch, the trust declaration of trust says that it's binding upon and fully enforceable as to each member and the successors and assigns of each member. And so I guess my first question is, doesn't that mean, I mean, I guess it might depend on how we look at the as to language, but doesn't that mean that the trust is enforceable by successors to the road commissions?
It could be if that successor was itself a road commission. The problem here was that the road commissions didn't become successor road commissions, they became successor counties. And as we've discussed, counties under the plain language of the bylaws, Articles 2, 3, and 4, have never been eligible for membership. And although the pool board...
Why does the successor to a road commission have to be a road commission?
Because that's what the articles say, that only road commissions can be members. In the same way, if you had a village pool and a village was annexed by the city of Detroit, the city of Detroit would not be a successor that would be eligible for membership in a village pool. You can't have a different entity. You could think about this in ordinary non-governmental terms too. Say that you had a collection of nonprofit colleges who all participated in an athletic association. If one of those colleges sold all their assets and liabilities and assigned all their contracts to a for-profit institution, the nonprofit athletic association wouldn't have to allow them to continue being a member. They could, if they wanted to, they could take a vote and allow a for-profit institution to participate, but you're bound by the documents.
It all sort of begs the question of whether they had an agreement like this one that seems to contemplate that successors to members could enforce the agreement.
Well, even if the athletic associations had that same provision, successors could, that doesn't change eligibility for membership. Even someone who is a full successor in interest, if they're not eligible to be a member of the pool, then they can't be a member of the pool. What if instead it wasn't a county that had dissolved its road commission and absorbed its things, but the state, acting through an emergency manager, had dissolved both the county and the road commission because they were financially insolvent, and then the state took responsibility for all those. I mean, in theory, perhaps the state would be a successor in interest, but the state would not be eligible to be a member of a road commission self-insurance pool. The members of the pool get to define who gets to be in it.
I agree with your last statement. The question is, I guess I'm not fully convinced as I sit here that when they say members or successors to members, that we should read into that the additional limitation that successors to members have to also be road commissions, because they could have put that language in that very provision that talks about successors as an entity different than the road commission itself, could they not?
Well, Justice Viviano, we read the contractual documents as a whole, and Articles 2, 3, and 4 of the bylaws make very clear that only road commissions can be members. So even if you have someone who is a successor, that doesn't mean they necessarily qualify for membership. In addition, I would point out that even under the statute that they're relying on, 224.6 sub 7, it doesn't say that the county is a successor to the road commission. It simply says that the powers, functions, and duties of the former county road commission transfer to the county. So even at the first step, they are not a true successor in interest, like a company that buys 100% of the stock of another company and thereby assumes all of its obligations and responsibilities. All it does is assume the powers, functions, and duties. But even after you get past that, there's still this threshold membership question that has to be answered. And because they are not road commissions, they're not eligible. And you have problems when you do that, because then all the insurance policies have to be rewritten.
Okay, thank you.
Justice Bernstein.
Counsel, good morning, and it's always a pleasure to have you in our court. It's always nice to see you. Just first have a comment and then a question. As I read through all the materials, this entire scenario reminds me of like Brexit. It just seems this seems like it's more complicated than the European Union, and the entire issue of Great Britain leaving the EU, I think, is less complicated than the scenario that we're dealing with here in terms of how this is constructed and what ultimately happens. And the first question I have, and I have like 3 questions for you. The first question is, why is this drawn in such a complicated fashion? And as you answer that question, the thing I'd like you to kind of, the point that I'd like to kind of really have a better understanding of is, who is this designed to benefit in terms of this entire structure? Is it designed to benefit the pool, or is it designed to benefit the members? Who is it that, that this is structured to benefit?
Thank you, Justice Bernstein. There's a lot to unpack there. First, I apologize that the briefing made it seem more complicated than it needs to be. This really is a matter of applying 2 plain language contractual provisions, defining who can be members and who's entitled to surplus equity. And to use your European Union example, the European Union only allows countries in Europe to be members of the European Union. If Australia fought a war with France and took over France and became its successor in interest, Australia would not be eligible for membership in the Union because it's not in Europe. I think that's a good example. To your question then about who this benefits, it's mutually beneficial. The county road commissions benefit because they have the opportunity to participate in a pool that has lower insurance rates than everybody else by spreading risk. What that means is that if a county has lots of liabilities in one year, it can rely on the other county road commissions in the pool to help pick up the slack for that. And it also benefits the pool because it's managing all of this, and it too can spread the risk. The problem when someone withdraws, which goes to the withdrawal provision, is that now the risk is shared among less people, and yet those liabilities don't go away. Like we were talking about, the child who was injured in 2010 by a county road commission vehicle in Ingham County can bring a claim today, and the remaining members have to pay that liability, and the party that actually incurred the liability gets off scot-free. And so that's why they're treated differently. But all the pool members benefit by this risk-sharing agreement. And when they withdraw, the risk-sharing takes account for that.
So would you qualify that, or I guess you would argue with the contention that it's a penalty?
Oh, this is absolutely not a penalty. This is simply recognition of the fact that the withdrawing road commission's liabilities remain with the pool for a really long time. I mean, potentially as long as 20 years when you think about a baby being injured until they become the age of majority, and then you add the statute of limitations on top of that. And during all that time when that liability risk still lays with the pool, there are no new premiums being paid by that member.
Thank you, counsel.
Thank you, Mr. Bursch. We ate up all of your time. I will turn to Ms. Toskey.
If I could just say 30 seconds for rebuttal, I'd greatly appreciate that.
Oh, you're so good at that. I might allow it. Let's see how long we go with Ms. Toskey.
Good morning. I'm watching the clock, so I can still say good morning, Your Honors. There are many ways to create successorship. Here, the Michigan legislature created successor status of the counties in Public Acts 14 and 15 of 2012. The Supreme Court, in the case we cited, Turner versus Bituminous Casualty, 397 Mich 406, a 1976 case, held in finding successorship for purposes of liability, that continuity through transfer from the first corporation to the second of its policy, its general business operations, its retention of personnel, and its retention of assets and properties was the major purchase of the acquisition and corporate change. Consideration for the whole deal was the phrase used by the court. The continuation of the normal business operations was found to be the key to successorship in Turner. Here, Your Honors, the counties assumed or directed all finance payroll functions, all cash, and don't forget, the county treasurer held the road commission's cash in any event prior to the dissolution and transfer. All budget development and oversight and monitoring of the annual budget, all purchasing, all human resources, all labor relations, all liability insurance issues, all workers' compensation insurance issues, all collective bargaining agreements. In the case of Ingham County, it took over 3 contracts, 3 union contracts, all health insurance plans and coverage, all pension plans. Again, in the case of Ingham County, all employees of the Road Commission were enrolled in the MERS plan, entitled to a B4 plan with a 2.5 multiplier. All retiree health insurance obligations, all retiree health insurance plans, and finally, the planning and responsibility for transportation being the key to federal funding and the income from federal funding of roads. Effectively, the Road Commission became a department of the counties. That's exactly how it occurred. The statutes created an assignment of all rights and interests, all assets and liabilities. Not a person or a pencil was left out. Pursuant to the clear terms of the 2 statutes, the county engaged literally in a seamless transfer or takeover of all operations, with the one sole exception before this court. I want to back up and let this court know that in the case of Ingham County, when it assumed all assets and liabilities, keep in mind, it assumed $9,787 in MERS unfunded, accrued but unfunded pension liability. In addition to that, Ingham County assumed $13,679,000 in other post-employment retiree health insurance promises that had been made, for a grand total of just shy of $25 million. The total was precisely $23,467,424.
Ms. Toskey, let me interrupt you and see what questions my colleagues have, okay? Justice Clement?
No questions right now. Thank you.
Justice Cavanagh?
No questions.
Justice Welch?
Yeah, I actually do have a quick question. So I'm wondering, assuming we agree with this notion of successorship, what do we do with the case that was cited, Century Indemnity, a federal case, I realize, but basically talks about that you can't impose a contractual insurance relationship between an insurer and a stranger to the insurance contract. How do we deal with that concept?
Well, don't forget, these counties were not strangers to this contractual arrangement. They had been paying premiums and participating year in, year out for many, many years, 20 and 30 years. And as to the issue of what about the injury or claim that is made 20 years later and the other remaining counties having, or road commissions having to pay up or cover that, that's not the way insurance works. The minute there is an injury, an accident, there is immediately established a maximum exposure or maximum liability is estimated, and reserves, what are called reserves, are planned for and set aside. And those surplus funds are surplus in excess of the reserves already identified, projected, and estimated to cover those losses that will come 20 or 25 years later.
Thank you.
Counsel, is it your view that your clients should share in future liabilities as well? I mean, if the pool has liability next year, can they come to your clients and collect their share?
My argument is that the premiums paid each year already covered sufficiently all pending claims. In fact, the underwriters were very willing to issue policies to reflect participation by these successor counties continuing on into the future. But even assume, Your Honor, that we were kicked out and could not continue to participate, those claims were estimated for maximum exposure, and underwriters in secondary markets already insured or reinsured those extraordinary exposures like death or serious bodily injury claims. So they were accounted for annually in each year's insurance premiums.
What if instead of distributing surpluses to the members, the pool decided to reduce premiums because it was ahead, financially ahead? Would your clients be able to ask for some kind of cash payout equal to the reduced premiums?
I'm really not prepared to address that. I appreciate the question. It had never, ever occurred in that manner in the entire life of this road commission pool. Always, the road commission had each year, with one exception, issued refunds of surpluses unnecessary to cover all outstanding or potential claims. So it is possible, I will grant you that it is possible, if that formula had been used and established between the parties, that may be true.
Justice Zahra.
No questions, thank you.
Justice Viviano.
No question, thank you.
Justice Bernstein.
No questions.
You have some additional time, counsel.
Well, I just wanted to follow up by highlighting the amount at issue, not that it's relevant to the outcome of this analysis, but this is a matter of form over substance. When all is said and done and distilled, this claim of the definition of two provisions, controlling and preventing, is a red herring. The board of the road commissioners pool voted not to clarify and amend to allow for the counties. It was an intentional act, not controlled ultimately by any provisions. But what is at issue between 2002 and 3 premium year and the final year of participation, for instance, by Ingham County being 2011-12, is a total of $1,495,300. That's the total refund allocation that has been made already by the pool. That's not my estimate or some expert's estimate. That is the pool's director's refund allocation to Ingham County for each of those years. So that's in part one of what is very serious here and represents, there can be no question, a significant punishment and deterrent from counties exercising their right under the statute, which is then the violation of Michigan's public policy, isn't it? When an act such as this kind of punishment is intentionally used to deter other counties from exercising that right, it has effectively amended, in some ways, the statute passed by the legislature, both statutes in 2012. Counties are going to think twice about whether or not, even if they were inclined on a policy basis to do a better job by governing the road commission functions, a forfeiture of $1.5 million would be a significant deterrent. Thank you.
Any additional questions for Ms. Toskey? Thank you, counsel. 30 seconds, Mr. Bursch.
3 quick points. First, you don't always get to reserve for past accidents. If you're not aware of the occurrence, then it can arise later and there is no reserve. For example, when an accident happens on an old, well-repaired country road. Second, the successor liability question is a red herring. It doesn't control who's eligible for the pool, just like the European Union members, and the plaintiff county's predecessors had no right to surplus equity on withdrawal. Finally, the public policy, they don't point to anything that explicitly says that what the documents say here, what the parties agreed to, is against public policy. And she says counties will think twice about withdrawing. Well, these counties knew that the pool's position was they would lose their right to surplus equity if they dissolved their road commissions and withdrew, and they didn't. They did it anyway. There's nobody who was deterred. And so the court shouldn't be in the business of making up public policy to contravene the parties' contracts. Thank you.
Thank you both. The case will be submitted. That concludes today's case call. See you in November.